Start. Subsection 1 of Section 141 of the NI Act required the complainant to aver that the present appellants at the time of the commission of the offence were in charge of and were responsible to the company for the conduct of the business of the company. In the present case, all that the second respondent has alleged is that the appellants were liable for transactions of the company and that they were fully aware of the issuance of the checks and dishonor of the checks. Para. Therefore, even if we decide to take a broad and liberal view of the pleadings in the complaint, we are unable to draw a conclusion that compliance with the requirements of subsection 1 of section 141 NI Act was made by the second respondent. The most important averment which is required by subsection 1 of section 141 of the NI Act is that the directors were in charge of and were responsible for the conduct of the company. The appellants are neither the signatories to the checks nor are whole-time directors. The decision in the case of SP Money and Mohan Dairy versus Dr. Snehalata Elling-Owen 2022 SCC online SC 1238 2023 1 AICLR SC 67 will have no application, as in the present case the statutory notice was admittedly not served to the accused. Obviously, the High Court has not adverted to aforesaid two glaring deficiencies in the complaint. Para. In the circumstances, the appeal must succeed and the impugned order is quashed and set aside only in so far as the present appellants are concerned. Accordingly, a complaint bearing CC number 112 pending in the Court of Judicial Magistrate First Class Nandyal is quashed only in so far as present appellants are concerned. Para. The appeal is accordingly allowed on the above terms. Para. Criminal Appeal numbers 884 and 882 of 2023. Para. This appeal takes exception to the order of the High Court by which the prayer made by the present appellants for quashing a complaint under section 138 of the NI Act has been rejected. With the assistance of the learned counsel appearing for the parties, we have perused the averments made in the complaints. Complaint case numbers 963 and 692 of 2011. The present appellants are the accused numbers 5 to 7 in two places in the complaint in paragraphs numbers 2 and 4. The second respondent complainant has averred that accused number 2 is the managing director of the accused number 1 company and accused numbers 3 and 9 are the directors of the accused number 1 company. Therefore, the present appellants are not even described as the directors of the first accused company. Moreover, we find that the averments in terms of section 141(1) of the NI Act are not found at all in the entire complaint. These facts were not noticed by the High Court. Hence, the appeals must succeed and the impugned judgment in so far as the appellants are concerned is set aside. Complaint numbers 963 and 692 of 2011 pending in the Court of Judicial Magistrate First Class Nandyal is quashed so far as the present appellants are concerned. Para. The appeals are accordingly allowed. Para. Criminal Appeal numbers 880, 881 and 883 of 2023. Para. The facts leading to the filing of these three appeals are identical. The prayer made by the appellants under section 482 of the Code of Criminal Procedure 1973 for quashing the complaint filed by the second respondent has been rejected by the High Court by the impugned judgment. The present appellants have been arraigned as accused numbers 5 to 7 in the complaint filed by the second respondent under section 138 of the NI Act. The accused number 1 in the complaint is a limited company. The accused number 2 is the chairman of the company, and the accused number 3 is the managing director of the company. The accused numbers 5 to 7 have been described as directors of the accused number 1 company. The only issue which we are called upon to decide is whether the second respondent has incorporated the averments which are necessary to be incorporated in a complaint under section 138 of the NI Act in view of subsection 1 of section 141 of the NI Act. The averments made in the complaints which are the subject matter of this 3 appeals are identical. Stop.